Thanks, Sean. Next up for a second appearance today, Danny Adkison of Oklahoma State University. He's going to talk about the 1964 Civil Rights Act.
All right. Greetings again. Thank you for being here. I thank Bill again for inviting us to this 3-year event that I don't know about you, but I always look forward to. I'm exhausted when I leave, but about a year before it gets here, I'm thinking, I wish it'd hurry up and get here for the 3-year conference. I think a lot of us go to these conferences. I was in Las Vegas in March. The year before that I was in Chicago. There's at the Midwest, there's 4,000 political scientists at the Midwest in Chicago, and yet you go to present a paper, and there might be 2 people in the audience. So you know, to me, this is the best of all worlds. When I was in Chicago, I was on a panel that I thought I knew something about, freedom of religion and the Constitution, and this young fella started. So I didn't take any notes. I didn't take anything. I thought, well, I can. You know, it was kind of a round table, and this fellow started talking about what was it? The Appalachian case. And I thought, oh my gosh, I had no idea what he's talking about. When they turned to me, you know, I got nothing. And it was the Allegheny case. And as I sat there, I thought, you know, I kept working this out, going, what am I going to say about this case I've never heard of? And but what the weird thing was, he wrote his dissertation on it. So,
Okay.
Yeah. But anyway, it's great to be twice in the same day talking about things we all enjoy researching and talking about. And I was thrilled that when I requested the 1964 Civil Rights Act, that Bill said it was still available. There's start out a little bit lighthearted. Do you recognize these lyrics? Well, they passed the law in '64 to give those who ain't got a little more. That's from Bruce Hornsby and the Range, which was a hit pop song in 1986. And a lot of people say it's referring to the '64 law. Some say it's also referring to a food stamps law, and some say it's referring to both. But most people don't catch that about that song. And so I want to talk about the '64 law. It's probably, I call it maybe the most significant law, certainly Civil Rights Act passed in the century. And well known by most people, even the layperson. But what you may not know is 2 hours after that law passed Congress, a lawsuit was filed challenging it as challenging the constitutionality of it. And that might not surprise you if you knew that you know, what we call as the meat or the heart of the law was actually copied from a late 1800s law, almost word for word, in which the Supreme Court had already said it was unconstitutional. So we'll look at all that as we look at this. Keep me within my time. Yeah.
I'll slap you.
There you go. So we're all familiar with the Civil War amendments. The Civil War amendments 13, 14, and 15. The 13th Amendment banning slavery. Unique in that it's the only provision in the Constitution that applies to us instead of just the government. We can't have slaves. The 14th Amendment, of course, the 1968, and one of the, as I mentioned this morning, one of the longest, 1868, one of the longest amendments in our Constitution. And the 15th Amendment saying you cannot ban voting based on race, and passed, ratified in 1970. one of the things to keep in mind, if you're not aware of it, is all of these provisions have what's called an enforcement act. It's turned out the Enforcement Act has become pretty important in the development of civil rights, using it to get the job done, not just to state something, but to make sure this is in fact done. The 14th Amendment, again the longest, starts out talking about citizenship. And of course, we mentioned this morning too. Chief Justice Taney went on this racial rant in Dred Scott for over 100 pages. And one of the things that the 14th Amendment does is overrule that case. Taney had said not only are blacks not citizens, but they can never be citizens. The 14th Amendment basically in the first section said they are now. And then, so it was one of those instances in which the court overruled the Supreme Court. Then the famous, what Russell called they had this great metaphor about the 14th Amendment, saying it's like a three-legged stool, that you have the rights to liberty, and the three they use are equal protection, due process, and what's the other one? Privileges and immunities. Yeah, thank you. And why would I forget that one? Because Rossum called it the load-bearing leg on the stool. And I think they're right. I mean, that's a pretty controversial thing to say, because if you've never heard of the Privileges and Immunities Clause, it's because the Supreme Court all but sealed its fate by saying that that clause means only those rights you have unique to the federal government, such as access to the seaports. And most of us don't run into that problem in most of our lives, and as a result, the Privileges and Immunity Clause has become a dead letter. So, but we have all that preceding the '64 Act. One of the first actions that was taken after the Civil War amendments was Congress used the Enforcement Clause. Remember, they all have, and the Enforcement Clause is a one sentence, I'll quote one: Congress shall have the power to enforce this article by appropriate legislation. That's it. So they used that wording, one of the first civil rights laws passed after the Civil War amendments were ratified. They used that wording to pass a civil rights law enforcing the 15th Amendment on voting rights. And the Supreme Court ruled in United States versus Reese that it was unconstitutional. Now remember, it says Congress shall have the power to enforce this article by appropriate legislation. In U.S. v. Reese, the court ruled that the law was inappropriate in that the way it did this. So, not a good beginning. I mean, here's the Civil War amendments that are going to be come to the rescue, hopefully, for all the bad things that have been done to African Americans in American history. And the very first time we get to enforce something after these, not a good beginning. Next, you had the 1871, it's called the Force Act, or sometimes the Ku Klux Klan Act. Here's what it did. Be it enacted that persons within the jurisdiction of the United States shall be entitled to the full and equal protection and enjoyment of the accommodations, advantages, facilities of inns, public conveyances, public amusement, subject only to the conditions and limitations established by law and applicable alike to citizens of every race and color. And so that looked promising, but that was challenged in the court in the case of U.S. v. Harris, and the court said that law is unenforceable because those places are not the state. Remember, the 14th Amendment has that important language, no state shall. And this was public conveyances and public such things. So there's strike two against, again, making racial progress. Then came the 1875 Civil Rights Act, and this one not only tried to correct inequalities in the government, but basically tried to eradicate the second-class citizenship that had been foisted upon the African Americans. So I'll read portions of it, the most important provision of it, assuming I can spot it here. It sought to end the second-class citizen treatment of those who were not Caucasian, laid the basis for what would become the 1964 Civil Rights Act. Fast forward to the mid-1900s, 1964, and the Civil Rights Act that we're discussing here. Now, one way to look at this, I think, is in Christianity you have sins of commission and sins of omission, right? And so a sin of commission would be doing something bad, like stealing from your neighbor, thou shalt not steal. But a sin of omission might be something like, you know your neighbor left his shed unlocked and he's going on a trip and you don't tell him. And then his new lawnmower and what have you is stolen. And you know, you didn't steal the lawnmower, but by not taking positive action and informing your neighbor that he didn't do something he should have done, you sort of take on some responsibility for the lost or stolen mower. Well, I think that's what's on Congress's mind in the mid-1900s. They're thinking not just, as you put it earlier, the negative and the positive, not just saying you can't do things, but how about, you know, letting individuals eat where they want, sleep where they want, and that sort of thing. The Constitution, if you think about it, gives us the right to be a bigot. As I said earlier, the only provision in the entire document, including amendments, that applies to private citizens is you can't have slaves. So it's a bit problematic when you start thinking about how the government can handle these sins of omission, which had, you know, I mean, we all know that you can't, just like Brown v. Board of Education, you can't one day say schools are segregated, and the next day they say, oh, you can go where you want, go to public school wherever you want, and then suddenly, magically, people are going to start doing that. You sort of need some nudging and some you know, positive action to get that done. So that's the problem Congress is facing, and of course they've got the civil rights cases staring them in the face. Now the civil rights cases were the cases that came after the 1875 Civil Rights Law banning racial discrimination in public accommodations. And that was just like Brown, there was 5 cases involved. They consolidated 5 cases. 2 of them involved African Americans who'd been denied access to a hotel. 2 of the cases involved African Americans who'd been denied access to a theater. And 1 of them was a female African American who was denied entrance onto a train. So here's the first major test of the 14th Amendment, along with the 3 major provisions we mentioned, being challenged in court. And what does the Supreme Court say? Well, once again, it reiterates that no, there's no remedy here because of the state action doctrine. The amendment specifically says no state shall, not your neighbor can't, or the person who owns a hotel can't, or what have you. It was an 8-1 decision. The dissenter, Harlan, tried to convince his colleagues that, wait a minute, they are public accommodations. Now, even though these are public accommodations, are privately owned. You know, it's not the U.S. hotel. It's not the U.S. train. It's companies and people who own these establishments, private citizens. But Harlan's point is that they cannot operate without public support of some kind. After all, think of the railroads. Who's getting them, who's exercising eminent domain to get them the right-of-ways? It's the government. Without it, you don't have a railroad. And, you know, the reason I emphasize that is because it resonates with me, that reasoning. It's like, I get that, but the other justices didn't get that, and so they ruled differently. John Kennedy sent a message to Congress in February of 1963. It was, he said, we need a civil rights bill. It was exactly within 1 month of the 100th anniversary of Lincoln's Emancipation Proclamation. One scholar who evaluated what Kennedy proposed wrote that Kennedy's words were strong, but his legislation was weak. So Congress didn't act. Kennedy sent them another bill a few months later, and he or his staff, whoever helped him prepare it, literally copied provisions from the 1875 Civil Rights Law, banning racial discrimination in quote-unquote public accommodations. That was, what did I say, June of '63. As we all know, a few months later, he was assassinated. All students that we teach learn that when they study Congress, that it's easier to block a bill going through Congress than it is to get it passed. Here are some of the obstacles Lyndon Johnson faced when he decided to pick up the thing Kennedy was trying to do and get it passed. One, the president had less than a year before the next presidential election. Two, Democrats controlled the House, but nearly half were Southerners. Three, the chairman of the Rules Committee was a staunch opponent of the bill. Four, just to get the bill out of committee, a discharge petition had to be used, a near impossible event. What number am I on? 5, multiple attempts were made to insert amendments into the bill to water it down. 6, the Senate chairman of the Judiciary Committee opposed the bill. 7, filibuster was used to stop the committee from acting. That was in the committee. Filibuster was used on the floor to stop the bill. And then George Wallace, who opposed racial equality, I think we all know, became the contender for the Democratic presidential nomination. So finally a filibuster was ended in that year, summer of '64, and a few weeks later LBJ signed it into law. The '64 Act had 11 titles. The most important were the public accommodations, Title II, some would say, and Title IV also gave the Justice Department power to sue in court. I've already mentioned that as soon as the law passed, within 2 hours, a lawsuit had been initiated to challenge it. And I'm not going to have time to go into it, but what I analyzed that I hadn't seen done before, which interested me, which is why I did it, but I sort of analyzed the oral argument before the Supreme Court when that case was challenged. And I don't know who Morton Rawlinson is. He was the lawyer for the Heart of Atlanta Hotel. There was 2 cases, of course, challenging the Civil Rights Act of '64, the Heart of Atlanta Hotel case, and then the case that's very little known is Ollie's Barbecue. So the idea was we'll challenge this thing in an urban area just outside of Atlanta, and then in a diner that holds, most people say it's a little tiny diner, held 12 people. It had 12 people that would sit at the bar, but it would hold I think about 100 and some people, but basically it was a diner catering to the locals that would sit at the bar. That way they'd cover both ends of the spectrums. And it's interesting, if you were examine the, one of the individual arguing for striking the law down, this Rolenstein, I've never read much about him at all, but you've all heard of who was arguing to uphold the law. It was Archibald Cox, the famous Yale law professor that became involved in the Saturday Night Massacre during the Nixon era. And it's fascinating to go through the oral argument because first of all, Mr. Rolenstein has this strong Southern accent, and which is okay, but but you know which side he's going to come down on the minute you start listening to him, and he is mad, basically. You can tell going through the oral argument, he is emotional. At one point, he turned to Cox and said, "Your arguments are hogwash." Now, who says that in an oral argument before the Supreme Court? I don't think that comes up a lot. But he got so angry, he just started lashing out at it. Cox remained calm and cool through the whole thing. And here's the thing. The justices, they interrupt during these oral arguments. So they interrupted both these individuals. And to wrap it up, when they'd interrupt him, the Southern guy, you could tell, didn't like it. Archibald Cox would let him finish, and then he just addressed them. Well, at one point, they asked and this is key to the case. This point is key. So they asked him, why do you think, where did Congress get the authority to pass this law? And the Southerner says, "You got me." And he says, "I'm an expert on this." And he says, "I'll tell you." I'm paraphrasing, but it's almost verbatim. He says, "I'll tell you, I owned a motel once. And if I saw an African American get in the swimming pool, no whites would get in the pool after that, ever." He goes, "I know that for a fact." This is the approach this guy's taking to an oral argument. Archibald Cox started referring to the hearings Congress held. Congress held almost 60 hours of hearings on this bill. They produced a 22-volume, printing it out, 22 volumes of evidence. And what did they show? They showed that they didn't base it on the 14th Amendment. They didn't authorize this bill on the 14th Amendment. They used Article 1, Section 8, Clause 3, the power of Congress to regulate interstate commerce. And when they asked the Rolenstein guy, "What about that?" he goes, I don't know anything about that. "Did you look at the hearing?" "I don't know anything about it." It was incredible. And so it makes you wonder, that they didn't get a unanimous vote, really. But the court struck it down. And here's the final thing. I don't know if you've ever thought about this, but think about it. The Supreme Court had said, both in the previous case and in this one, the Supreme Court had said that it was illegal. It was constitutional to allow segregation. It was constitutional. But Congress can make things that are constitutional illegal, and that's what they did. They said, "Okay, we'll just make it illegal based on the enforcement of interstate commerce." It was a no-brainer with Heart of Atlanta Hotel. That's interstate commerce. But Ollie's Barbecue, how did they get that one in? Well, as you all know, Ollie's Barbecue got 75% of its meat, mostly hot dogs, from out of state. All right, thank you. Sorry, I took a little too long.